Hi, Chris.
Hi,
Good
Amanda.
morning. Good
Good
morning.
morning.
Thanks for joining me.
It's a pleasure to join you.
Okay, so Chris, you are the International Man of Mystery. Would you take a minute and introduce yourself?
Well, there's nothing mysterious about it. I'm just simply a parent in Scottsdale who happens to be a corporate attorney. I've 24 years of practice now in corporate transactions, primarily in venture capital, software licensing, complex mergers, acquisitions. My clients are mostly overseas. From this, went to law school at the University of Washington. After law school, I lived and worked in Tokyo at a big law firm there before going in-house at a Fortune 500 US company to work on their software licensing and acquisitions in Japan. Before that, and then after that, I made a lateral move back to Seattle to become the general counsel for a venture capital fund with about just shy of $1 billion of capital under management, where I worked for quite a long period of time. And 4 years ago, Seattle had been gradually changing. And then as I had young children of my own, I wanted to find a place that I could live a little bit more freely. And so I came to Arizona with high hopes about the state of Arizona. It is different. And I saw what was happening with the school boards back there in Seattle. And it was concerning. So I continue to do that work on the legal side, and I continue to work with my clients overseas. And I just happened to, like, never paying attention to school board meetings, but I just happened on that May meeting where the school board, the Scottsdale School Board, ejected parents, closed it down. And that really got my attention. During COVID, I had to watch these board meetings, figure out what was going on with the schools, what was going to happen. Are they going to open up? Are there going to be masks? Going to be online? What have you? Because before then, I really did not care. But when I saw these board members sitting there, stone-faced, ejecting protesters, and of course the camera, I'm watching on the YouTube channel, the camera doesn't show the parents and what they're doing or what they're saying. Are they holding up signs? Or, I imagined the worst. I just was really taken aback, and I thought, I need to pay a little bit more attention, because I'm hearing and I see online that maybe the parents were objecting to masks, or they were objecting to certain new proposed curriculum at the school, and there was a reference to a diversity committee that they were demanding to understand, and I had no understanding of any of these issues, but 2 days later, I really got angry. I had I had an emotional reaction when I saw the superintendent, whose name I didn't know at the time, sit in front of a press corps at the school district building, seated next to a police officer in full body armor and armed and masked. And I thought, what the hell is this? This is not normal. This is not, this should not be happening. What's he doing? And then it just got worse from there, because this police officer, Amanda, looked into the eyes of the camera and said, if you don't like the direction, I'm going to paraphrase, right? Paraphrasing here, officer, I don't know your name, but if you're going to come to the board meetings because you don't like the direction this board is going in, and you don't like the facts, he's the term, facts and circumstances that the school district is putting out there. If you're just coming to bully them with your opinion, we're going to step in. The law enforcement will step in, parents. And I thought to myself, this is absolutely ridiculous. Can't get worse. It does get worse, because then the police officer says, I have a unit back at the headquarters. It's my intelligence unit that monitors social media posts related to school board matters. And I thought, this is absolutely ridiculous. This isn't Fallujah, Mr. Full body armor, armed police officer sitting next to a school superintendent. Something's going on in this district, and I better pay attention, because I know, as a refugee, a political refugee of the Seattle area school systems, these changes happen, and they happen quick, and they happen before you know it. And once you've realized it, it's too late. I better start paying more attention. So I get online. I think, what is this committee things? I had just finished up a huge client transaction in the spring, had a little bit of time. I thought, I'm going to look into this. I do what lawyers do, corporate lawyers, and we diligence. I go to the website. I take a look at the board minutes and the meetings and what they've been talking about. And it's like, I'm not seeing anything about proposed curriculum. I'm not seeing anything about a diversity committee. What's happening here? And so I knew FOA. I knew about FOA. I didn't know really how to do one. And I thought, this will be fun. I'm going to start sending public records requests to the Scottsdale School District and see what they do. And the first time I used their form, there's an online form. You can just put your name in and briefly summarize what you're looking for. First time I did that, I was like, okay, give me the formation, the composition, what work they're doing on this diversity committee. And I get back 5 days. I thought, hey, this is prompt. This is really prompt. 5 days, I get back a stack of materials that told me really not much about what's going on, but enough what I did see didn't make sense. And so I sent another one, but this time I lawyered up the letter quite a bit. And I said, look, I started digging into the statutes. What are the public record laws here in Arizona? What should they be giving me? What's off limits? What can be withheld? What is confidential? What is not? And made a second request. Second request produces some documents that comes back, much of it repetitive, not helping me understand what's going on. Now my nose is up, right? Because when I diligence a transaction and I start seeing red flags, you start to sniff more in that direction. And so I started going there, and I sent a third letter, really formal, very lawyeristic, asking for more information. And what did I get? I still got, nothing that really gave me good answers. And then I happened to come across a meeting for a community of like-minded parents here in Scottsdale. And I met Amy Garney. I said, I listened to the speeches and I came up afterwards. I didn't really have much time. I said, hi, Amy, I'm looking at this too, and this doesn't make sense. I don't understand what's going on. She said, well, keep in touch and see what's going on. I said, okay. So I go back into my silo. I'm like doing the legal process. I'm doing the diligence. I'm going through the meetings. I'm watching the YouTube videos, right? Because you look at these publicly posted minutes of these meetings, and it doesn't tell you much, right? It doesn't really tell you what issues they're discussing. And a lot of times it just tells you what their decisions are going to be, that the legal actions they're taking. And so you don't see all the work from before that. You got to dig deeper. And then I met this woman called Amanda Ray. And she showed me this parents.
Oh, the Arizona Parental Rights Handbook.
Arizona Parental Rights Handbook. And I thought, oh, she's got all the statutes. It's a compilation of statutes. And I thought it's from the Department of Education. And I started looking through this, and I'm thinking to myself, wait a minute, they're not following this. Where does this come from? Is it old? I had to look it up. Maybe it was superseded or something, because they're not following these statutes. And that's when I got really, really curious about the other type of sunshine laws, which besides public records requests, that is one form of what they colloquially call sunshine laws. There's the open meeting law, and almost every 50 states have them. Arizona's had one since the 1960s. It's been revised a few times as courts were trying to chip it away and trying to define what is an open meeting, who is applicable to open meetings. But there's an open meeting law. And as I'm looking into the open meeting law, I'm looking through this parental rights handbook on curriculum adoptions. And I see that the open meeting laws are supposed to apply to these curriculum adoption committees formed by districts for the selection and review of any new educational materials. Now, what I saw at the public board meetings, as I'm still doing my diligence, what I saw, besides the meeting that was shut down, I just saw some staff getting together and presented that they had been meeting. They may have had 1, 2 parents on their committees, because it's very hard to find people that are willing to volunteer, they said. And I thought, well, that sounds legitimate, right? People aren't volunteering, they don't have time for school boards, but actually, no. The statute requires you to have a public meeting anyway. It doesn't matter how many parents are on the meeting. The open meeting law doesn't guarantee a certain composition, right, or the number of people that should be on the committee. It requires you to have a public meeting. So I dig into the sunshine laws, this open meeting laws, and that's when I really understood there's something very significant happening here. And in the state of Arizona, liberty-minded state of Arizona, it's a fundamental right of parents to direct the upbringing, the education, and their health and mental health upbringing. And that statute it's a fundamental right, right? So what does that mean? Okay, Arizona used to be a territory. It means that right existed before it was even a territory. Mm-hmm. It means it was part of what the Declaration of Independence say. We hold these truths to be self-evident, that we are endowed by our Creator, right? It comes before the government, and a school board is sure as hell not going to transgress that fundamental right that the legislature in Arizona has incorporated into the open meeting law, requiring that these curriculum adoptions be put before a public meeting. You have a right to attend. You have a right to listen to their deliberations, see how they vote, see the issues they talk about, see what they're disagreeing about, right? That is exposing your government and the decision-making process to the public, because the fundamental purpose of the open meeting law, and I know you were going to ask me this question, is that the fundamental purpose of open meeting laws is to ensure that your government decision-making, it doesn't happen behind closed doors. This is a government, this is a self-governing democratic government where we rule ourselves, not by experts in a closed off room in the back who work away on things you don't know about, don't understand, don't even know they're talking about, and then later emerge from the room and present it to a governing board for rubber stamp approval as a fiat accompli. Already done. The work's already done. No, the open meeting law requires everyone that's going to be along the chain of that governing body, the board, to show their work, because this is important things. Only the governing board has legal authority to approve those curriculum adoptions.
Yeah, so let's talk about that curriculum adoption specifically. And I want to give you a perspective, so how you can answer from a parent's perspective, because without having any legal education or knowledge, I went to that April board meeting because, exactly like you said, I didn't know that a curriculum committee had been formed because it had never appeared on any agenda prior to. The process for forming those committees had been for the school district to reach out to the Scottsdale Parent Council and ask for volunteers, which did not go to its member base. It went to their board members only. So it went to one person who then was responsible for asking the board members of the Scottsdale Parent Council.
That's the nonprofit organization organized in Scottsdale, been around for a long time.
Correct. And it's been rumored to have been considered the 6th board member. And now I understand why they've gotten that reputation.
The shadow board member.
Exactly. Yeah. So from that, so I saw that appear. I saw curriculum adoption appear on the board agenda, but no history of it ever being introduced before. And then all of a sudden it was being presented to the board, and I couldn't find anything else behind that. So as a layperson, I was stuck on the Arizona Parental Rights Handbook, which is all I knew about, right. In that I hadn't been notified about it. I didn't have the ability to be involved on it. Bad timing. I'll let that go past.
We're just parents. We're not a news.
We're just parents. I don't have an assistant here answering my phones today. So I'll let it go. I was stuck on not being involved in the committee and being part of that process. And what I didn't understand, and I had gone to the board and during a public comment asked them to delay the vote. And what I got back from Dr. Guerin.
You were one of the parents expelled?
No, well, I was actually at the mask meeting. I was at the, but this is back in April. So this was 2 meetings prior.
Okay.
So in April, I stood and did my public comment and said, it's my parental right to have an involvement in this committee. And I wasn't aware of it. And I'm asking you to delay the vote and not adopt this curriculum until you give us the opportunity to review the curriculum. Now, I was also stuck on the 60 days review, which
Right.
they did. They quietly put it on the website, didn't announce anybody that it was there. And unless you were checking the website and digging deep into those levels, you wouldn't have known that that was there. And because it hadn't appeared on an agenda, they posted it in January.
Yeah.
But it didn't appear on an agenda item until April. So it gave nobody any clue as to look back and see what was being produced. Now, Dr. Guerin stood and defended her recommendation, saying we followed the spirit of the law,
Right.
and we were unable to
that.
provide. We were unable to provide textbooks because of COVID, which to me, that just gave us more of an opportunity to make more people aware, because if you can post the links online to curriculum, that means more people can review the curriculum instead of having to physically go down to the office.
No, but by that time it was too late. As I
done.
mentioned in my open meeting law complaint, those curriculum adoption meetings had already started in the fall.
Correct.
It was too late at that point.
Yeah.
This was the moment they're presenting for fiat accompli,
final
stamp it.
Final vote.
And you weren't alone. I know there were a number of other parents at that meeting.
Correct.
Similarly saying, look, we don't know what's in this curriculum.
Right. So in May, at the mask meeting, when they shut it down, I was there. I was physically in that boardroom. It was not, as the board president called it, a belligerent mob. There were angry parents, understandably so, but it wasn't violent. Nobody felt unsafe. There were children there. Had my children been with me, they would not have felt afraid.
You didn't carry pitchforks?
There were no pitchforks.
Torches?
Later, board president Jan Michael Greenberg said that they shut the meeting down because Arizona is a strong Second Amendment state, and that there was concerns that we would be armed, which is ridiculous. I mean, I had my purse and my heels. I mean, that was how I was armed.
Right.
So as a parent who wanted to be involved in this, it felt like a slap in the face, and it didn't feel very democratic. And it just felt wrong, but I didn't have the statutes to tie it back to,
right.
Which is when you started looking into the OML specific to curriculum, it started to even get me more incensed, because what I knew in my gut was wrong was actually really wrong. And the violations were more significant than I even knew.
That's right.
So the problem with that committee was that it was formed, it wasn't noticed, it wasn't agendized, there are no
they seem to have had, I try to develop it in my brief to the Attorney General, they seem to have had this process that they had evolved over time, developed internally with their own internally set definitions of categories of educational materials, with the matrix of at what level of approval for those categories they would go to. There's your basic textbooks, your supplemental books, your ancillary materials, and then on the very bottom of the rung was something like teacher selected materials that the district doesn't support financially or provide teacher training for. And I'm going to quote, under the oversight of the principal. Okay, so that's going to be anything that the teacher takes online and she starts using it. Yeah, she's not getting supported by the district, right? So there's no financial support for materials. There's no teacher training from the curriculum development teams at the district. They're just pulling it off the website and teaching your child about it under the oversight of the principal. So didn't go to the board. So yeah, I mean, what you felt in your gut is exactly what the open meeting law is supposed to prevent, because those curriculum adoption committees with their internal definitions and their internal processes, which this current governing board thinks they've improved that process, by the way.
They fixed it going forward.
They fixed it going forward because they follow the law, and they're concerned about having more parents apply on the committee hub. Committee hub, right? You probably heard of the committee hub. That's a web page.
Right.
It's not a public meeting. The point of the open meeting law is to provide, and there's two different statutes now. Now we've got, with curriculum adoptions, we've got the curriculum adoption statutes from Title 15 of the Arizona Revised Statutes regarding education. Okay, those are a whole set of education-related statutes. Then you've got the open meeting law, which is a whole different set of statutes regarding government employees and official conduct. Mm-hmm. They're incorporated, meaning that the open meeting laws apply to certain educational statutes. One of them is curriculum adoption, the 15.721, 15.722, and that is in your parents' handbook. Mm-hmm. Right? And I didn't know it was there until you showed it to me, actually. And that set me off a lot, because it can't be any clearer. And then it gets worse, because the more I scratched, the more I realized every year in January, this board has an open meeting law training session. Okay. And so the first year that I reviewed was in January 2020. And at that open meeting law training, that was conducted by the Arizona School Board Association General Counsel. It doesn't get any more top expert than that guy named Chris Taylor, who gave a presentation to the board on the open meeting law. And I've used actually quite a bit of his materials in my brief to the AG. But he explained to them, these open meeting laws don't just apply to you, governing board. It applies to the subcommittees you create underneath them, okay, that are doing the work of the board. Okay, so that's good. It's still a little confusing, and this is why you asked the question. It's still a little confusing. Why does it apply to anyone else other than a majority of the board? Well, because in the 1970s in Arizona, courts were facing a similar question. Well, are these advisory committees to public bodies under this new open meetings law that you passed in 1962? Do they apply to these other committees? And the courts at the time in the 1970s were the first time that they were really dealing with these issues. They said, oh, no, actually, they don't. The legislature was infuriated and revised the open meeting law to specifically add subcommittees and advisory committees to the board. And the reason is simple. Again, we're talking about transparency. Transparency laws should make the workings of the government transparent. Don't go behind closed doors and do all the work and then come up to the public body. The public body, and that's a defined term in the statute. Don't come up to the public body and then just present all your work and have it rubber stamped. Because part of transparency is seeing the deliberations, the proceedings, and these are all legal terms, but everybody understands what they mean. It means when you talk and you meet and you have discussions and you prioritize issues, you're doing it in front of the people, the public, right? And so the open meeting law was revised in the 1970s to include these subcommittees. And
can I ask you a follow-up question about that? Because that was a question that I asked of the curriculum committee, specifically asked to Dr. Menzel, Dr. Guerin, and the legal counsel in the room at that time in a scheduled meeting, where I asked why the deliberations and proceedings of that meeting were not made public. And the response that I got from Paul Becker, who was the secondary ELA coach on this committee, was that they were trying to protect the identity of the committee members, because they were concerned about retaliation. And then they were also trying to protect the identity of the curriculum providers. So is identification, and identity and competitive information, is that an excuse to have a closed door meeting?
Okay, so the answer is no, absolutely not. As a public body, And as a curriculum adoption committee, subject to both the open meeting laws as well as the curriculum adoption statutes in Title 15, the curriculum adoption committee must hold their meetings in public. And that's not optional. It's not, oh, I don't want to be outed because I'm on this committee. First of all, you shouldn't be concerned about that issue if you're on the up and up.
Right.
That question kind of relates to this category of, well, I don't want to be exposed to the political pressure. Well, no, that's exactly why you have to have public meetings, is because there's the legal process and then there's a political process. And if people are shut out of those meetings, they can't have access to how you're deliberating, what you're thinking, how you're prioritizing issues, what is going to be important, what's not going to be important, which direction are you trending towards, right?
Mhm.
Because I need to know that if I want to step in politically and apply pressure, as is my right. Because remember, we're talking about a fundamental right of parents to direct the education of their children. So that kind of political concern, right, is just nonsense. On the publisher side, oh, well, our publishers have, proprietary materials, there's copyright concerns, they can't discuss. Well, sorry, you're government contracting, and in government contracting, which the school board is,
Mhm.
and in government contracting, the rules are different. You want to bid, it's going to be open. It has to be. We're subject to open meeting laws.
Right.
You structure your bid around my laws, not me violate mine to meet your proprietary commercial concerns. That's not how government contracting works. And so that was a really unpersuasive position to take if that's what they told you.
Okay. So the other question to that too is, or the point to make about that is they also used COVID as an excuse for having although we know from looking back that this is their standard process, but that they said, well, we didn't provide the textbooks because of COVID and surface contact, but Attorney General Mark Bronovich.
Yeah, that sounds right. So your question is, well, does COVID affect that, right?
Yeah.
And the answer is no. And in fact, this particular Attorney General, in March of 2020, issued an opinion. He's foreseeing this issue, saying, guys, even in a pandemic, you still have the open meeting law, and that's not going away. There's other things you can do to comply with your obligations under the open meeting law. I'm not going to hold it in abeyance during the pandemic and lockdowns. You're going to figure out to do it. This is the 21st century. There is video conferencing technology. There is YouTube live streaming, right? All the public needs to be able to do is be able to attend and listen to those deliberations and proceedings. Live stream it. You can do that.
I mean, I would argue that COVID actually made it more available to more people because we were using more technology, and perhaps they didn't want that. They didn't want to invite extra people and extra eyes into the room and looking at that curriculum adoption. No,
they didn't. And it's kind of funny, not knowing local politics or anything, but this AG was totally on top of that issue at the very beginning, because that was a warning letter. That wasn't, somebody sent him a letter, hey, can you give me an opinion on this? No, it was a warning letter he foresaw for himself. I better let people know you're not going to use the pandemic as cover for holding closed door meetings. The business of the government will continue. We're not shutting it down. Your fundamental rights continue to apply, and that's the right of the public to attend and listen to the deliberations and proceedings of their public bodies.
Right. So aside from curriculum,
But before we move on, and I know you have a long list of questions, but I want to make sure that because I can get a little long-winded because I've been so absorbed in these materials. But when we talk about curriculum adoption committees and the open meeting law, I want to make sure that people understand this is kind of a separate, because we have these two different statutes applying, the education statutes and the open meeting law. That curriculum adoption is its own little creature. Right. And going back to training, and your meeting with the general counsel at Scottsdale at the time, I don't know, was that Michelle Marshall?
No, it was Lori Bird.
Okay. Michelle Marshall, and I included it in my brief, actually, a screenshot of her slide deck informing the board, because this is the annual open meeting law training that they had in January. In January 2020, it was this Chris Taylor, the Association of Arizona School Boards. But in 2021, it was Michelle Marshall, their general counsel, and she called them out specifically saying, we don't really use this term advisory committee of the board, but we do have one, and you call it the curriculum adoption committees, and they're subject to the OML. She's got one beautiful little slide there with references to the applicable statute, and I included them on brief because it's just so incapable of a multitude of different interpretations that with respect to curriculum adoption committees, it's very clear. Open meeting law applies. Governing board members don't even have to be in that committee, okay? Public body members, the school board members, they don't have to be part of that committee. It could be anybody.
Right.
And then the OML will still apply because Title 15, your education statutes in Arizona apply to it, specifically curriculum adoption. There are other committees, however, that I discovered as I diligenced this, when I started seeing references to Menzel's subcommittee system. I mean, that was the phrase used. Menzel,
yeah, what is a subcommittee? What's a subcommittee system?
Yeah, what is that, right? Subcommittee first is defined in the open meeting law as an advisory committee, an ad hoc committee, a standing committee. Any committee of a governing board of a public body would be considered an advisory committee, a subcommittee of that board, because they're taking a portion of the public work of which they have legal authority, right? They have legal authority over curriculum adoption, over policy making, over strategic planning, over committees that are studying changes to curriculum through diversity efforts. Those are solely within the legal authority of the governing board, right? The district, their staff, okay? With respect, their staff that report to the board, and only the board has that authority, and they were granted that authority by the statute because there are representatives, and we're talking about fundamental rights. So somewhere last November, I start seeing in the record of these meetings talking about subcommittees, Menzel subcommittees for policy changes. And then I said, well, policy changes, only the board sets policy, right? Only the board has ability to policy. Superintendent is charged, just like a CEO in a corporation. He reports to the board of directors. His only authority is what is granted him by the board of directors, okay? It's the same in a school board. Superintendents are charged with implementing policies set by the school board. And it's a very apt analogy, the corporate law analogy. And but I start seeing in the records that Menzel is working with Greenberg and maybe someone else, and they're proposing changes to policies regarding harassment, sexual discrimination, I mean, major policies that apply both to employees of the district, but also students.
Right.
And then they just present at the full board meeting on YouTube, right? A fully redlined version. You know what a redline version is, right? I mean, it means they've gone back, they've done all the work, they've got some proposed language, they put it in shown word tracking, shows it as a red line on the screen there at the public board meeting. But they've already done all the work. And then they just go to the board to say, well, this is what we've done. And we think you'll like this. It's approve these policies. It's like red flag, okay? And then I start seeing other references to Menzel subcommittee systems. And it really went on overcharge after this superintendent Menzel was hired in June last year. And at that time, Greenberg was not a board president, right?
Right.
He became president in the January 21, just before the vote. I mean, and this is why lawyers diligence this stuff to find it. Just before the other board members vote on who's going to be the president, and it looked clearly from body language and such, that Greenberg was the only one volunteering to do it. He gave a nomination speech. And in his speech, he said, you know, we've been making great progress in these policy committees. Mr. Menzel, Dr. Menzel has introduced this subcommittee system for us. And it's making things go a lot faster than holding board meetings.
Isn't that nice?
Isn't it nice? And I'd like to see that, right? And the message was, we're going to do more under my leadership. We're going to get more done. We're going to use Menzel's subcommittee system. And the other board is Libby Hart Wells. But yeah, I'd like to see that expanded in other areas. And I think there were other comments that says, you know, we'll do this. The general counsel at the time, Michelle Marshall, said, yeah, you know, this is Menzel's system. He made these policy changes based on what he was doing back in Michigan.
Right.
says that. It's on camera. Okay. And Menzel is on camera saying the policy committee is doing the substantive work of changing policies. That raised obviously a lot of issues, because a policy committee is now working on something only the board has authority to do, right? Whatever work the subcommittee is doing is under the authority of that board. And they are a derivative of that board. Their authority is subject to the board. They're doing legal work to make a recommendation to the board. Doesn't the public have a right to see that? Yes, the open meeting law says you have a right to see that. It doesn't matter that you don't have a quorum, because I see this.
Okay, I was going to ask you about that, because that's what I'm. The pushback is there's nothing to see here because we didn't have a quorum. That is
so the issue of quorum is so inconsequential to the issue of whether your committee is a public body that I don't really spend a lot of time thinking about it. But I'm glad you brought it up, because it's important that people understand. It is easy to get confused. Well, there's 5 board members. So you need 3 to have a majority, and that is a quorum, which means that the board has formally met. It's a formal meeting, and the formal meeting must be public. Well, yes, that is correct. That is the application of the open meeting laws. But when a board creates a subcommittee beneath that, they don't need a majority of the board members to serve on that committee. And the question then becomes, from a legal perspective, question, is that subcommittee a public body for purposes of applications of the open meeting law? And yes, it is. The answer is it is. Okay. So now I can talk about a quorum at the public body level. I can talk about a quorum at the subcommittee level. And at the subcommittee level, if there's only 1 board member, it doesn't matter.
Right.
If there's public members, it doesn't matter.
Right.
The quorum of the subcommittee is just going to be a majority of that subcommittee, which quorums are only important when you're actually voting on something. I don't think any committees actually voted on anything, because they didn't hold public meetings. They didn't put a notice out with an agenda, with particulars, right, of saying what they're going to talk about. And only these items. Right. That's when you vote, right? Because that's the deliberative process that has been cut out under the Menzel subcommittee system. Right. I don't know. I really hope that helps, because people do get confused about that, and they get focused on that 3-member board. For voting purposes, you need a quorum of that board, but that board can create other boards under that, and those are the subcommittee systems. And apparently Menzel has implemented this on overdrive. It's gone on steroids. These subcommittee systems now, I saw references just in the public records of what I've reviewed of a finance subcommittee, of a strategic planning interview committee, right? Where they interviewed consultants who were not invited in a public bid, but in a request for quotes. There was an interview committee for that. And that was one of these subcommittees. Obviously kind of pretty important there. And then I think there's quite a number of others that I just not popping into mind now, but it is a system. It's being used, and the board liked using it because it was really efficient. They got through policy revision after policy revision.
Nobody's slowing them down.
They couldn't tear it down. They're like, hey, this is working.
Yeah,
I love it. We're so efficient.
So efficient. And I think you the individual that you quoted earlier who did the training,
Chris Taylor.
And yes, he
didn't. General Counsel for the Arizona School Board Association.
Yes, thank you. Didn't he specifically state that open meeting law still applies? It being efficient is not a substitute, or is not an excuse.
You read the brief. Yes,
I read the brief.
Yes. That's exactly right. He made a point, and he made a point to say in front of that board, and that was the old board, there was the former board, sure. But the rules are still the same, that the whole purpose of the open meeting law is not to make your job easier serving on a board. And I sympathize with you. You're volunteers, you're unpaid volunteers, and I really do sympathize and appreciate someone stepping up and performing a civic duty. But the OML is not made to make your job easier. It's to protect the public interest, and the public interest is in seeing their representatives and people that report to them and make recommendations to them and do all of the substantive work of the board, seeing their deliberations and their proceedings. You can't avoid it. It's just the way it is. If you're going to have transparency in government, this is the way it is. And that's why it's so important that people follow the OML. As we know, recently, this Attorney General has chastised a school district here in the Phoenix area, Litchfield Elementary School District, for OML violations. Now, there was a slap in the wrist because it looked to be, it was just one committee involved. There were 13 members, only one board member on that committee, okay? It was a committee formed to study changes to the curriculum through a diversity empowerment team. Okay, curriculum, is that the superintendent's authority? No, only the governing board. Outside the State Department of Education, the governing board approves curriculum, policy, right? That's it. Superintendents are executive functions. They're not the legislative function, which is what a board is. So they got reprimanded. Yeah. And I think someone just resigned from that board too.
They did. Yeah. So in regards to the curriculum committee and the board's responsibility there, I don't have the exact quote, but in that curriculum adoption meeting where they did vote on it, board president Jan Michael Greenberg did say in that meeting, paraphrasing, it's not my job to review the curriculum that's being adopted. It's my job to make sure that you follow the law.
Yeah. Yeah. So I've got, it's a 250-page complaint, right? A large portion of that is my diligence report. And I pull out those quotes specifically. And I did so on purpose because it shows a fundamental misunderstanding of your role as a governing board. You're actually required to approve these curriculums. There's no one else.
Right.
And there are other statutes on the books in Arizona that says the school board has an affirmative duty, an obligation. It's not discretionary, it's mandatory, regardless of how you feel about the issue, to exclude from the curriculum, from textbooks and educational materials, denominational, non-sectarian materials that may be controversial. And no, he got it actually, completely backwards. And we're not talking about banning books. We're talking about setting curriculum. What we want collectively as a society pass on to our children, what's important for them to understand, to grow up, to be, well-read, well-spoken children and well-spoken adults, and well-educated adults. That is part of our cultural heritage that we're entrusting these institutions to pass on to our children. And so you absolutely can exclude items, right? People always talk about critical race theory and it's all about learning the history and everything. Well, yeah, there's a lot of things that happen in history too. And there's other theories of history. Marxism has a theory of history, but we don't require our kids to study it, right? It's a theory of history. Catholics have their own sense of history and the interplay of of this world with the world and the history of salvation. I don't expect my school boards to be teaching the Catholic, right, philosophy of history. So they hide behind pedagogy to introduce concepts or scholarship that parents probably don't know about, probably would object to. And that's why we have representatives on the board, and that's why they are the only ones that can make those decisions. And my job as a lawyer is to look at the legal process they followed, and they didn't follow the legal process. And parents like you become so upset and angered, and they organize, and you put on what you're supposed to do, which is the political pressure to change, right? The laws are only going to be just sitting on the books unless you guys actually step up and do something about it. And the law can't say, well, I know you wanted to be on that committee, but you don't have a legal right to be on that committee. But I can tell you that that committee meeting must be public.
Right. Well, what's interesting about that is when we did start to put pressure on them and we tried to host informational events for parents, we were cited with a cease and desist letter, or we were sent a cease and desist letter which felt like intimidation. They didn't like us getting.
Oh no, it was very intimidating. It was from a lawyer, right? It
was from an outside legal firm to a group of moms saying that we were causing confusion in the community, and I think our flyer talked about what to look for in controversial curriculum. Clearly, it wasn't being put on by SUSD. They don't want anybody to know what's controversial in the curriculum.
Right.
It was clearly done.
I think you had your own branding, didn't you? There was some other branding associated with those. So that was totally bogus. There's no legal basis for you to stop using SUSD as part of your political organization. They do not own the rights to SUSD. It is a trade name. Now, you can't set up a business under SUSD, but that's not what you're doing. And you're not using their logos, right? Those beautiful I'm sure very expensive
Right.
logos at the time.
No,
when-
we
from the
specifically
70s
didn't.
with the mountains and the cacti. I mean, that's not what you were doing. No, they sent that letter to intimidate you, Amanda, and to intimidate anyone else who might raise up a question. And this is part of the problem that school boards are doing across this country, is they're intimidating parents to not speak up. I mean, you're worried. I'm worried. I have kids in the district, right? I was one that's going to be looking for college application and recommendations very soon. I don't want anything to come back on me or my children.
Sure.
You know, we're Americans. We have rights, and what's wrong is wrong. What you felt in your gut that this is not right, you were right. It's not right.
Well, then there are other groups, in particular the Scottsdale Parent Council, who were using SUSD, and it had never been a problem. But we were the ones.
This is the nonprofit, right?
The nonprofit had several Facebook groups that used the letters SUSD, and that had never been a problem. And they were not sent a legal notice. We were sent.
So it's even worse than intimidation, was selective.
Right. Selective intimidation. Exactly.
Right. So, you know, do you want to spend time on that? We could hire lawyers.
We got rid of that. We got rid of that issue.
Because it's not important, because what you're really concerned about is change in the district, right?
Right.
And that was a childish, to be quite frank, that was an amateurish legal move. And not just legally a bad strategy, but in a PR terms, terrible strategy to adopt. And I don't know who did that, right? I don't know. I don't think.
Well, what's interesting is the law firm that sent us the letter was actually the same law firm that the Attorney General sent the Litchfield
Gust
letter to.
Gust
and Rosenfeld. Gust and Rosenfeld.
Yeah.
So,
well, it was a completely amateur legal move. And
right.
It was a completely amateur political move, right? I mean, look at the backfire. Why would you do that? You don't do that. You don't have any reasonable basis to do that. No one's getting confused here and making a consumer choice question, right? You're going to be cut down. ASU, Arizona State University, I'm a Husky, not a Sun Devil, but ASU recently was in court trying to sue some kid who was using ASU and his COVID parties dude. Right? He had a whole series of COVID parties dudes that, with memes and things like that, using the symbols, using the maroon and gold, and ASU took it seriously. Who knows how many thousands of dollars, hundreds of thousands of dollars they spent on attorney's fees to take this kid who was anonymous. They still didn't even know who it was. It was this anonymous kid, dude, holding COVID parties, and the judge just tossed it just last week.
Yeah.
And rebuked ASU in a funny opinion I really enjoyed reading, because come on, no one's getting confused. No one's thinking that the ASU is holding COVID parties, dude.
Right.
So it's the same thing. Your SUSD, there's nothing. But look, you know, you move on, because we don't have time. We're parents too.
Right. Yeah, it was a distraction. So last Friday, a public comment that I made was the subject of the SUSD communication email, and a clarification of misinformation that was out as a result of the public comment that I made. So
yeah, I think there were 5 bullet points, and you were a majority of them.
Yeah, unfortunately, yes. And there's 2 reasons I want to bring that up. The first one is as it relates to the strategic planning committee. My comment in that meeting was that in that strategic planning committee, that we believe is subject to open meeting laws, those
Absolutely.
deliberations and discussions. I know that during those discussions, there was talk about Cheyenne traditional model.
Right.
And there were several people in that 48 or however many people group that have pushed back and said, you know, maybe Cheyenne isn't innovative, you know, maybe they don't believe in school choice. As a parent at Cheyenne, I want to know that those discussions are happening. So unfortunately, people
Cheyenne that's the traditional curriculum. You have kind of your own little thing going on there in the district, right? No other school just like it.
Right. So I think we're the only one that has, you know, Saxon math and Spalding, but by some it's considered not innovative. So, but what got lost in there, because I only had 3 minutes to address the board, was that, and my point was to get people thinking about this. Unfortunately, it caused undue stress on the principal of that school to have to respond, but that the curriculum is not changing. But the fact of the matter that it was brought up behind closed doors.
Right.
And what could have happened is if there had been, let's say, there had been more people in that group in favor of changing Cheyenne's curriculum than not, that would have been held behind closed doors, and that would have been brought to a vote to the board, and we wouldn't have known what had happened, but it would have just been done. And then we would have been looking in the rearview mirror. Instead, I want to make sure that as parents who are invested in the traditional curriculum, or any, for that matter, anything happening at any individual school, if it's on the chopping block, then we have a right to know.
If it's even being discussed.
If it's even being discussed, correct?
Right?
Yes,
right?
and that was my
putting
concern.
it on the chopping block would have been a governing board decision, but they might have been deliberating on it. Okay? They might have been studying it, and there might have been enough voices to say, well, let's take this up and let's work on this, because we've got a strategic plan, and they're not part of it.
Right.
So that's the whole purpose of having open meetings, is you'll be able to see that and cut it off right when it happens. And that strategic planning committee is subject to the open meeting law. That is an advisory committee to the board. The board created that. The former president, I can't remember her name, Beckman maybe.
Beckham.
Beckham. Beckham. She last summer, she said, guys, our strategic plan is expiring at the end of this year. We need a new one. Menzel said, hey, I got Greenberg. He's tasked with it. He's tasked with it. I got him. He's going to work on that. And this is a 5 to 10 year planning document.
Right.
It's supposed to reflect all of our collective, goals, aspirations for education. I think that's important for the board. I think only the board has authority to make a strategic plan. You're damn right they only have the authority. It's not a superintendent committee. He doesn't have legal authority to do that. That is a classic subcommittee of the board and is subject to the open meeting law. Now, it's a little interesting question, because Menzel has staffed that with quite a number of people from the community as part of his community involvement, right? But that's not the point of the open meeting law, is that some people might get hand selected after they apply to be on that committee. That doesn't make it suddenly transform it into a public meeting. That's just a closed door meeting of more people.
Right.
They're doing work and they're not showing the work. And they're doing stuff like maybe putting your school on the chopping block, or at least want people to think about it. And this is why you have a right to transparency in your government, so that you can respond and you're not cut off before you even know, and before it's too late, right? That the changes are already in place, are going to be rubber stamped by a public board.
Right. Yeah. I mean, I don't want my inability to serve on a committee to be why things get changed in a direction that I'm not comfortable with, and then only find out about it after the fact.
Well, let me ask you, I'm going to turn this around. How did you find out about the strategic planning committee?
Because I had conversations, casual conversetions outside of that committee, so it was hearsay.
Another parent, multiple parents that were part of those discussions. So it was hearsay, but it was from a trustee, obviously a trustworthy source. But don't need a source. I just want to illustrate.
Yeah.
These are closed door meetings. This is how telephone works, right? And everyone repeats the child's game, and you don't know what was really said at the meeting because it was a closed door meeting.
Right. So it leads me to
So obviously you're going to think the worst. Other parents are going to think the worst. Now the principal finds out about it and he has to respond. And I think I saw that response and it was not satisfactory. It was kind of lawyerish in the response. But that's why, strategic plans are only done by our elected representatives, right? Or the people they form to go study the issue and make a recommendation.
Right.
That's a subcommittee. It's an advisory committee. And this is a classic advisory committee. Well, I'll tell you, I didn't know anything about the strategic planning committee until I went through all the videos, because it's not it really doesn't appear in the minutes of the meeting, right?
Right.
With the written minutes, I had to go and watch the superintendent comments section of every meeting. The superintendent comments usually shows up on these notices and there's nothing there. And it's like a blank line.
Right.
Oh gosh, what's it going to say, right? This superintendent has taken that, and you're permitted under the open meeting law, the chief presiding executive officer can make certain introductory comments, make some announcements. They're supposed to be non-controversial. They're just supposed to be things you celebrate the community, recognize the teacher, recognize some kids.
Right.
He used that exception under the open meeting law for superintendent comments, where he just used it as his platform to inform the committee of what happened, inform the community of his committees. That's strategic planning in particular. And I have a long list in the brief of every time he was briefing the public on the progress of the strategic planning. We're still meeting. We've got another long meeting. We're making great progress. We're doing the heavy lifting. This is a quote. They are doing the heavy lifting, but there'll be opportunities for involvement later. And then next thing you know, there's a public meeting where they've got phase one already decided, and they got it's already done, right? There's a little picture of the mission and values and whatever. But where did that come from? That came from behind closed doors. Okay. It's wrong. And by the way, I don't know, you haven't asked me, but there are sanctions under the open meeting law. They're for violations, right? I mean, it's not.
Well, yeah, that is one of my questions. Yeah.
Yeah, good. Well, I'll jump into it right now, because when you violate the open meeting law, and whether you know you're violating it or not, whatever you decided at that meeting is null and void. Those are legal words in the statute: null, void. And everybody, I think, understands what that means. It means it doesn't have legal effect because you didn't have legal authority.
Right.
Right. So when it goes up to the board, okay, then they approve it. But down here, there was the violation. Okay, they can prove it back up at the board, but here was the violation. And so when there is a violation of that subcommittee, the statutes provide they got to go back and redo it. Right now, I've asked the Attorney General, and this is my own thing. Right? I've asked the Attorney General, craft a remedy here. I don't know what the remedy is. They've gone so far, and the use of these subcommittees is so systemic and chronic and pervasive. I don't know how you fix this, Attorney General.
Right.
I really don't have any other than just being a stickler for the law. I mean, it's null and void, right? It doesn't have legal effect.
Well, they adopted $3.3 million worth of curriculum.
$3.3 million worth of curriculum without a single public meeting. That's right. That's your money. And these are 7-year contract terms. Yeah. It's a long-term commitment.
Right.
So, despite all of their open meeting law training, despite the fact that the board president is an attorney himself,
who has written extensively about OML.
Who's written on right, freedom of speech, and on your open meeting. Yeah, that was the other one. Despite this, they still adopted the subcommittee system, and they still continue to have curriculum adoption committees not in compliant with the statutes. What do you do, Mr. Attorney General? Right? How do you fix this? How do we unwind it? They've already entered the contracts. They've signed it. Well, in corporate law, you say you didn't have authority. It's an illegal transaction, right? You don't have authority. Well, the third party that just got your money, for them, it was a valid transaction. So who do you hold responsible? Right. Right. Here's the other side to sanctions. That's why I bring up the training and why I emphasize that this is not new information. They were trained in the open meeting law by attorneys licensed in Arizona. I'm not even licensed in Arizona. I'm just reading the statutes like any other parent. Right. But they were trained on it. They knew it. And in knowing violations of the open meeting laws, it's $500 for the first time, for the second time, and after that, it's $2,500 per occurrence. How many times does that curriculum adoption meet? That's a lot.
Yeah, I mean, I think they met every 2 weeks, or at least monthly.
2 weeks from September through their adoption in the spring. Okay, boom, 2,500, 2,500, 2,500, and who pays it? Guess what? Here's the incentive for board members to get it right. It's your personal liability. The school cannot indemnify you under their director's insurance. They can't provide insurance companies to represent you if there's a court case involved. Right? Okay, so the Attorney General could actually go to the court and seek to impose these fines. Could also seek to remove you if it's a knowing violation. So this is not, a teethless, non-enforceable statute. It actually has some real grip to it. If the Attorney General finds that it's egregious and that they knew it. They knew what they were doing. I don't know. I've got several quotes of the superintendent on camera saying, we follow the open meetings law. We know what it is. I would be pretty nervous if I was him right now,
Mhm.
because that adds up. Because he's not a governing board member, but he assisted it. And the statute reaches down into the staff and puts
Right.
that personal liability on them just as much. So
Right.
I don't know, it's out of my hands.
Yeah.
What the AG will do, but from what I've seen, and we know that there are other public interest law firms interested in these cases. What I've seen is the Attorney General's office will look at it favorably and take a look at it, but
Mhm.
we may not know about it.
So just make sure we cover. So you brought up First Amendment, which you filed one complaint with the Attorney General, but then following the other subsequent 3 board meetings, 2 of which were held online, you followed it up with a second complaint, and as it related to First Amendment and open meeting law again, and how those 3 meetings were conducted.
Right.
Do you want to
Right.
speak to that?
I'm going to pull out that copy of my second
Yeah.
brief out of my stack of materials.
your
SUSD,
OML binder.
Lawyer for me. It was so egregious what they did. Yes, I filed the first complaint. It was on a Friday. It was the 20th. It coincided with the recall petitions,
Yeah.
petitions, but that was just the day as soon as I could get it out.
Right.
And then you had these meetings on the 17th, the 23rd, and the 24th,
Mhm.
25th. Okay, so let's talk about that. So the open meeting law does apply to
Mhm.
these public meetings and calls to the public. It's called a public call the public. The board does not actually have to require you to speak at these board meetings. It's not part of the open meeting law. You have no right to speak. You do have a right to attend and listen, though. Attend and listen.
Mhm.
I'm just reading from the statute.
Sure.
So, but however, if the governing board opens the floor for calls from the public in a public call, an open call, they can't censor the speech. It's a limited public forum. It's the town square. They can't tell you what you can speak about, what you can't. It doesn't matter that it's a public hearing and not a special meeting, which was the distinction I think the district was making. And quite frankly, they're just getting bad counsel regarding. They're a government body. And the government can't restrict your speech at a school board meeting any more than they can restrict it if you were to attend city council. You just can't do that. So you've got First Amendment issues to speak to you want. And what's really particularly ironic about that meeting was the public hearing was required under this new statute that's been adopted regarding instructional models.
Mhm.
Okay, I don't think anybody understood what was this instructional model. Certainly everyone was calling in not to talk about the instructional model because they didn't understand what it was. Well, I looked at the statute. Yeah, the statute for adopting an instructional model, that statute was designed so that schools get credit for online learning, right?
Mhm. For funding, yeah.
For funding, right?
Mhm.
Well, why would they be doing online learning? Because what's going on? COVID. It's a COVID, right? It's a response
Yeah.
to COVID and pandemics.
And
It's
a result
absolutely-
of their own quarantine practice of
Exactly.
quarantining students in excess.
That's right.
Healthy students.
Scottsdale has Scottsdale Online. Kids could go there. Right?
Mhm.
That's a platform you never hear about anymore, right? I mean, so you had to have the cameras, and then now they've got this other instructional. So anyway, the statute for adopting this instructional time model was drafted in a way that required the school board to have 2 public hearings. Okay, no one explained this to anybody. It required the school boards to have 2 public hearings before they could adopt that instructional time model, which was right arising out of response to COVID-19 and the pandemic. Well, what else is a response to COVID? What else is a public health measure? Masks, right?
Mhm.
It's logically related. It's all part of the same thing. We're all responding to COVID.
Sure.
How disingenuous of you to suddenly tell me that I can't talk about masks at this meeting? Well, you're talking about COVID. You're talking about health responses. What measures your school board is going to implement to tackle the crisis? And so I watched and I took notes. I took meticulous notes I had the first name of every caller that called, and whether they're pro-mask or anti-mask. I have the time right down in my notes of where they were interrupted and stopped, and the telephone terminated. Those are all violations. I mean, it's egregious violations of the First Amendment. And as we have subsequently learned, this board president himself has written to prior boards on First Amendment issues and censoring speech, and has a whole memo on it on his personal website.
Yeah, and he was the one
Under the
actually,
section that's called First Amendment.
yeah, and he was the one in the chat box
Section
cutting the mic.
First Amendment. See, here's my letter to the board. When they were trying to, when they apparently they had a policy that you couldn't criticize board members. It was no, they were going to censor speech. I mean, he was absolutely right about that. You could criticize them all you want. You could go to a school board meeting and talk about the purple fairies and Smurfdom, and they can't cut you off. They set the time, place, and manner of 3 minutes in this room. Speak respectfully. You know, that's it. That's all the government can do to control your speech. They can't do anything else. And that was egregious. And it was worth, and the AG's office doesn't want to keep receiving complaints. And so I asked respectfully, I'm sorry, this is egregious. And now this is a whole nother level, because we're not just talking an open meeting law violation, right? We're talking First Amendment issues, right?
Right.
On an issue of major concern to the community, masks and mask mandates, wherever you fall on the issue, don't you want to follow the right legal process? Don't you want to follow the law and implementing it? Because if you're not interested in following the law, then you think that the law doesn't apply to you, then what are we? Do we have any fundamental rights anymore? Or is coronavirus, does that just supersede all of our fundamental rights?
Right.
It doesn't. No, it doesn't.
Right.
So that was one. And then the next.
The second one.
I mean, it's like wham, bam, bam. You know, I couldn't have written a novel that would be anywhere plausible to what this board is doing, and then the mistakes they make each along the way, right? I mean, it's who would believe
a bad
this?
reality TV show.
Right. Right. Like the screenplay, then it was just not plausible. You know, they wouldn't do that. But yeah, actually it did. It gets worse. And this is the theme that I have, and getting involved in all this, is that it always gets worse. Yeah. And at that last meeting where community had organized, they found out about it. And so I guess they decided to make it virtual instead of in person. And
right. So they cited, so this is what I was hearing, is that we were the subject of, I don't know who these people are, but we're subject of law enforcement chatter. And the SPD had picked up tips from social media that we were going to be there. Of course we were. I have encouraged every parent, every parent that I can to show up at the meeting and use their right to speak. And so that became so. And I have a problem with that. It's very.
You should.
It's intimidating to be told that you're showing up in law enforcement chatter, and then I get an email from the attorney telling me where I can stand, in which I'd already figured out for the petition signing.
Which attorney is that?
Miss Lori Bird.
The general counsel to the district.
General counsel for SUSD had sent me a personal email copying the security officer, saying that
as if you're responsible for this.
Yeah, that she had heard from law enforcement that I would be there with petition signings. Which I wasn't making secret. I absolutely was. The sidewalks are public property. We knew exactly where we could be. We actually spoke to the police when we got there to make sure we were in the proper place. But that the way that the structure of that meeting, which was part of that complaint too, the structure of that meeting was they made it virtual because of security concerns. So the board barricaded themselves in a boardroom behind security, behind police officers, where
they were there.
The general public was left to be outside in 105 degrees.
Right.
I wasn't able, I had to take a comment card and get a number. And then I was unable to hear, I was number 16. I was unable to hear the board opening, what was discussed. And when I had people texting me and chatter in the crowd of what board president, Jan Michael Greenberg, was saying about
Yeah,
these
you had to scramble to figure out what's going on, right?
I was
'Cause you're
mad.
on the
I went in
outside.
there. Yeah, I went in there mad because I heard him saying that there were security threats about a neo-Nazi propaganda comic book, which I had seen in public records, was they had an employee on paid leave because of that. And so if that's the case, then why is this still a security concern? And why am I now being excluded? I'm outside, not able to listen to that, nor the next 15 minutes or the next 15 speakers speak, which I then heard he was being disrespectful during their public comments. And it infuriated me that I was stuck outside in the heat, not able to participate in that public meeting, and walked in blind as to what had transpired before me, and then spoke, and then ended up being
It wasn't 15, it was 39.
39. Okay.
39
Yeah.
people in the comments.
Oh, well, so my number was 16. So 15 went before me.
Okay. Oh, right, right.
But then I left and didn't get to hear the however many
The other
after
public
me.
comments?
I did not get to hear. I had to drive home. And then at that point, I heard Patty Beckman questioning them on the formation of the audit committee and whether or not that was a subcommittee or a superintendent's committee.
That was a very interesting moment for me. Actually.
Right.
Yeah.
Right.
Yeah, I mean, clearly they know about the AG brief. Right? No one wanted to serve on that audit committee.
Right.
Yeah, so I won't speak to that one because I haven't filed anything on the audit committee.
But you did file on the structure of the meeting on the 24th, where we were not allowed to participate.
So I did. So let's look at this, right? Assuming it was true that there's a genuine security issue. Let's assume that what Scottsdale Police Department did by monitoring social media, open source social media, is not problematic under the laws of the U.S. Constitution or those in Arizona for your right to privacy and to politically organized. Let's just say that was a legitimate security issue. The choice that the board had at that moment was, well, do we have this meeting or do we call it? Right? We could postpone this meeting.
Right.
It wasn't an emergency meeting, right?
No.
We need to approve these funds for the fire department to put out the building that's destroying our campuses right now. This was not an emergency meeting. We have to evacuate for a national disaster, right? No. This was just a regular meeting, actually. It was a regular meeting of the board, right? So they had a choice, and instead they chose this other alternative under the direction of the police department, according to their words, which the police department doesn't have powers to, hold the open meeting laws in abeyance or the U.S. Constitution. They then structured the meeting so that anyone who wanted to make a public comment, like you or anyone else of the 39 people that made comment, or anyone else outside who was probably dissuaded from making a public comment, they forced you to stay outside. Did they give you any electronic equipment, like in an overflow room where you could see them on a screen and hear what they're saying?
Nope.
So would you say—
We know they have an overflow room. They've offered to use it before, but they did not use it that night.
I wish I would have known that. So they didn't use the overflow room. They forced you outside into the heat, and
where a woman passed out.
Okay, so I mean, those are the consequences of these decisions that they make, and I wanted to go back to, they didn't provide AV for you outside.
No.
Here's a radio, right? You can listen to us on the radio, right? They're not on the radio, they're live streaming. That's how old I am. But they're live streaming on YouTube. They didn't set anything up. So for anyone that wanted to make a public comment at this public meeting of a public board, you were denied entry to attend and listen to the proceedings, right? For you, it was a violation of OML, right? You individually can sue them in court. You individually can go to the AG and say, I have suffered a legitimate injury here, a damage, a violation of my rights to attend a public meeting. It's egregious. You can't do that, right? You had a choice. You could call the meeting, postpone it, reschedule, and comply with your obligations under the open meeting law and as common decency requires. Instead, it looks to me as though you made a political statement that you were excluding certain people from that meeting that you didn't want to hear from because it was unpopular for you. because it might look bad for you. And I understand you had a celebrity, somewhat of a celebrity in line. I saw him myself. Charlie Kirk is right. He was there. They probably knew it. I don't know if they knew it, but they might have known it. And they didn't want that on television, right? Of him in the audience. And it still got to speak, which is I'm really happy about, because he brought up my complaint. But still, for you people, you were denied your ability to attend an open meeting of the public because you were not allowed to attend and listen. And I'm not the only lawyer out there who has talked to the AG about this.
Right.
That particular meeting.
Right.
And I know that for a fact. Because it is so egregious. You can't do that. So, and so on an urgent basis, I asked the AG to consolidate my original complaint into these additional egregious violations, because it's just too important. The issue is going to get worse. We can expect mask mandates to be talked about for the foreseeable future, and I would wish the AG would step up and put a stop to it, right? Expose it. That's what transparency laws do. It's a disinfectant when your public officials have to speak in front of you, right? And so excluding you and excluding so I don't see your face. I don't have to see your words. It's easier for me to kind of go about my business, right? No, I mean, that's the whole purpose. You attend, right? So they can see you, see that you're interested, that you're engaged. It's your right. And it's actually their obligation. I mean, we talk about duties all the time, but or rights, but we don't talk about duties. Right? You have a moral duty to this. And I think they failed the community with that. And I'm sorry you had to experience that. I wish there were certain things we could have done differently. But
some of the ridiculous pushback that I'm hearing from people in our community in support of the board is that the prior board and superintendent were corrupt. So we should just let them do their jobs and be supportive. It's not okay to call them into question because the previous board was so corrupt. And
they're trying to fix it.
Like, what's that?
And they're trying to fix it.
They're trying to fix it. We should be appreciative that these people have stepped in and tried to fix it. And my point or my thinking in this is that because that occurred and we're aware, I am more aware going forward that you don't dismiss them because they're coming after a corrupt board. You stay on it to make sure that you keep them honest, because that happened because we weren't paying attention. And they have a history of not following the law. So it's even more important now that we make sure that our new board and our new superintendent are held to the law.
Yeah, I mean, comments like that are just really about, hey, this is my team, don't criticize my team. Right. And this is us versus them. This is my team, don't criticize my team,
They mean well.
They mean well, and they're volunteers. And I totally sympathize that you are volunteers, but you still have to follow the legal process, follow the law. Right. There's a lot of problems there, and there probably was some prior corruption. My understanding was before my time, before I was paying attention. So I don't really know, but that involved money, right?
It did. But and that's why and I don't have the history there. It was before I was paying attention. But that's why particularly I want to know about this 3.3 million in curriculum. Like why did they choose Savas? Why did they choose the people that they did? Who has a connection to them? If you're not telling me, how do I know that it went out to 4 different publishers for bid? Because maybe they just sent it to one, and maybe somebody knows somebody at Savas and got a kickback. I don't know that because
there is that possibility, and then you want to see what the publisher actually prepared in response to the bid, right? Why is his materials better than the other guys? Part of the deliberation process, and to know what's in the content. How does your content differ from his content?
Right.
We don't know.
And I've requested
in closed doors.
I've requested those records and they don't exist.
Right. So, I tried public records. I wasn't getting anywhere. You're not going to get anywhere. There's got to be something else that compels them. And, they've got some staff that's spending all their time on responding to public records requests. Like, I don't want the records after the fact. I want to know what's happening now. I want to see open meetings so I can respond when I need to, so I can step up and pay attention when I have to.
Right.
on an issue that I care about.
Right.
That's a political process,
Mhm.
right? And the law is designed to support that political process, and everything you described, you're attending, you're organizing, your exclusion, you're wanting to speak, is a political process meant perfectly naturally and to be expected in this country to put pressure on the board. And there's nothing wrong with that. You do more of it. You have to do more of it. Because
Right.
clearly what they're doing, this happened to me in Seattle. We woke up and the boards were lost. The curriculum was lost.
Right.
I had no idea what was going on. And I was like, let's get out of here. Let's get out of here.
Right.
I'm teaching your kid. And that's in Washington, where you don't have, Arizona has a culture of liberty. And it's true. It's reflected in the statutes because I knew Washington statutes, but we didn't have these fundamental parental rights, much less a handbook that they got to produce.
Right.
And in Seattle, in the state of Washington, a teacher can take your daughter at 14 to an abortion clinic without your consent. And you don't have to know anything about it. And it's in the law. We could talk about whether that's a just law, whether it's the right law or not. But I just throw that out there as an example of where in Arizona, you're very fortunate that have parental rights as fundamental rights in your statutes.
Mhm.
But you got to be involved to know, to get to know about it. And so, you can't just keep hiding your work, guys. You have to show your work. That's what the law is. You're not getting good counsel.
Well, if my fifth grader has to show her math work, I think the school district should have to show their work.
Show the work, maybe. Show it.
Right.
Well, what other kind of questions do you have for me here?
I guess my last
take more of your time than you
No,
expected.
it's been fantastic, because I think that it's really important for the layperson to understand what this really means, because it is difficult to read the legalese and understand how it actually applies. But you've done a great job explaining to the layperson like how this impacts us as parents and what our rights are. So I guess in closing, my last question would be, these two complaints are in the hands of the AG. We've seen that they've come down and cited a neighboring school district, Litchfield United School District, for a similar but less egregious.
The AG has reprimanded.
The AG has cited them for a similar but less egregious.
Less
and more of
egregious.
a finite.
First of all, it was just one committee.
Yeah, one committee, and then one open sign being held up. But
one violation of one meeting.
Right. So what's the what are the anticipated next steps? So it's in the hands of the AG. There, like as you said, there's other
quite
public
frankly,
interest.
the AG is subject to political pressure as well, right?
Correct.
So the AG has the authority to seek enforcement, but he doesn't have the obligation. That's the way I understand it.
Okay.
They probably disagree. They might say, no, we have to enforce. Okay, fine. But you don't have to call me and ask me about my complaint. You don't have to call me up and give a hearing and give my testimony or anything like that. You just take my complaint, you put it on your desk, and you do the analysis to verify the contents of the complaint. And then you give the district another opportunity to respond to the allegations in the complaint. And then you decide to investigate. And so right now it is in the AG's hands. I suspect that the district has received a phone call. I certainly, if I was counsel to the district, I would immediately pick up the phone to the AG's office if I found out about this through other means.
Right.
I would immediately call the district and say to the AG's office and say, how can we fix this? Right? Because I didn't really leave a lot of room for error. Now, there's some conclusions of law that only the AG could really make, but I think the case is fairly well documented, 250 pages, well supported by the record, showing a multiple number of systemic violations of the open meeting law. And you just can't do that, guys. There's no way to run a district. So my hope is what happens next is the district starts making changes. We will know that they're making changes when people at committee meetings, when these committee meetings are changed, right? When the schedule
Canceled, changed, the structure.
Right? Board members aren't showing up.
Yeah.
What's going on? Okay, that tells me there's something going on behind the scenes, which we won't know about.
Right.
But
we have the right. We have the right to ask the district.
Absolutely have the right. And so yes, thank you. Full circle. Yeah. I think the AG is susceptible to political pressure, just like I think the board is susceptible to political pressure. I mean, you as a public have a right to go to a board meeting and say, what's up with the OML complaint? what are
Mhm.
your response to the OML complaint? Are you going to
Mhm.
respond, well, that's under a legal investigation, so we can't really talk about it? Well, I don't know. I'll go check the statutes, whether that's exempted from what you can discuss or not. But you
Right.
can confirm the existence of an investigation, right?
Mhm.
And then political pressure at the AG's office, quite
Mhm.
frankly. I know other public interests have looked at it,
Mhm.
but the AG's office needs to hear that this is important to the people of Scottsdale and that it's urgent. It really is.
Right.
Because it just gets getting worse, right? There's an escalation with those meetings that we just talked about,
Mhm.
where they're cutting people's First Amendment right to speak. They're
Mhm.
shaping how those meetings are structured in a way to exclude you because you're
Mhm.
opposed to them politically.
Mhm.
These are egregious violations that you need law enforcement. This is where you need law enforcement. And the AG
Right.
is the top law enforcement agent in the state. You don't need law enforcement monitoring social media, high SPD.
Mhm.
Right.
I know. We look really dangerous, don't we?
So dangerous, right? Yeah, I respect the blue, but not on
Absolutely.
this. Not on this at all. There's
Yeah.
just no superintendent should ever sit in front of a full body armored police officer and threaten a community like that. That's ridiculous. And it pissed me off enough that I got involved. But I'm
Yeah.
very happy because I met you. I met some other wonderful parents in the community. I really tremendously respect
Mhm.
your energy, your enthusiasm that you bring to these issues. It's so important that you keep it up, that you organize, speak your mind, don't let anyone tell you differently. Just keep going. I work in my silo. Can I pitch my Twitter?
You can.
Yeah.
It's your Twitter.
So I set up a Twitter account just for this, right?
Yeah.
Because I kept getting all these, issues and
Yeah.
people aren't understanding this. So let me put it out there, at a legal process. Okay.
At a legal process.
That's
Okay.
right. Follow it. I mean,
Yeah.
I try to set it out and try to explain these issues. If you have questions, let me know. I don't have a lot of time because I got a job, right, and a family. But it's important enough that I think people need to see it. And this issue is going on across the country.
Yeah.
What's happening in Rhode Island, where teachers unions are actually suing parents, right, for public
Yeah.
record.
Oh, yeah, exactly. Yeah. Yeah.
Um,
To the point where Goldwater's gotten involved with that
Yeah.
one. Yeah.
In
Well,
Indiana, I'm following a case in Indiana right now. It looks very interesting. And again, I got to tell you, we're very fortunate to be in Arizona with such a liberty-minded history and culture and legal tradition, and
mhm.
baked right into the statutes. We are free people. We give you our kids to educate,
Mhm.
but not indoctrinate.
Right.
Okay. Whatever you decide to do, that's fine. I mean, you can probably tell from my political leanings and some of the comments that I made, and then that's fine. If I lose the war, I lose the war, but it's got to be a fair process. And this is not
Right.
fair.
Right.
You've got to follow the right process.
Yeah. Well, Chris, thank you so much. And I just want to express the gratitude from our community. You have become a hero and for a lot of us, and particularly me, because you took those. I have a very strong justice meter, and when things feel
Great.
wrong, I didn't have the legal aptitude to put the statutes to what I was feeling, but you absolutely did
You know
that.
what, Amanda, even if you did, this school board wouldn't have listened.
That's true. That's true. But and that's why I'm so
That's
appreciative
why they're
that
excluding you now. Yeah.
Right, right. But I do have great hope that the what you've presented to the Attorney General is so thorough and well put together that there's absolutely no way they can not address it. And so we'll continue to, as parents, put pressure on the district and the Attorney General and make our voices heard and make sure that we get our rights back.
Right, right. I'm not some big law firm, right, with a big brand name, right?
Yeah.
And the reality is, judges listen to the big law firms. They do.
Yeah,
when those big law firm members walk into the court, the judge notices what he says a lot more than he notices you. And the same has got to be true for AG and other things. So I'm just an average guy that did the work, put it in and made my report and filed the complaint. They don't know me from Adam. So we all need, if this is an important issue, and I think it should be, an important issue for you. If you want to be politically active, you have to know where the fight is. And if they close the doors, you don't know where they're fighting. You
Right.
don't show up. You can't show
Right.
up.
So to that end, how do we, with the Attorney General, how do we make our voices heard? Call his office and say that we want to send emails? What's the appropriate channels to
I'm
make
not
sure that
going to
we,
encourage anyone to do that.
I mean, I've tweeted
I'm just saying the
Barbranovich. I don't
concept
know.
is that they should be amiable to hearing from the public on matters of public
Okay.
concern. But I'm not going to, yeah.
We're not going to storm his office, but is it, so we should be calling, we should be sending emails. I've tweeted him.
Call, email, say, these are important issues.
Mhm.
We know about the complaint, right? And we hope you're investigating because we think we're right.
Yeah.
If we're not, let us know. Right?
Sure.
We'll think about something else, right? Because we could be wrong.
Yeah.
But it is important to us. And these mask mandate things is not going to go away. There's the division, the breakdown of trust between parents and the school boards. It's important. And there's more battles coming, as we know, because of changes this summer that were implemented to what curriculum may or may not contain in the state of Arizona. So big battles are coming. You need to know that those meetings are open so you can see them, right?
Right. And that's the frustration, Chris, is that as parents and not as lawyers, we have repeatedly gone to the district and asked for transparency and let us be at the table and show us what you're doing, do all of these things. And we were met with resistance. And so
not just
we didn't want to
resistance.
go here. Yeah, not just
hubris.
Yeah. Right.
We are the experts. We're
Yes.
questioning our jobs, our judgment, our professionalism.
Right. Nothing to see here.
Nothing to see here. Rely on the experts. As this
Mhm.
particular board president said, we have to rely on the experts. We don't want to ban books. Actually,
Right.
your job is to ban books because
Right.
there's only a finite universe of books that kids can study in school. Some of them worthy it, some of them not. You have
Right.
to make a decision, and that's called a moral judgment.
Right. Right. Yeah. And
What
nobody's
your
suggesting
moral judgment is may not be mine, but
Right.
when you make your judgment, you're going to be in the public, and I'm going to see it because it's in
Right.
a public open meeting.
Right.
Right?
Exactly. Exactly. Yeah.
I really enjoyed our talk, Amanda.
Yeah.
I wishing you the best. I'm here to help support anytime. If there's more questions, let me know. But you can also follow me at Legal Process.
Yes. And I'll put a link to it
Process.
at a legal process. Yes. Thank you, Chris, for your time. I really appreciate it. And I'm excited anticipating to see what the Attorney General says about this issue. So we'll make sure to.
Fingers crossed.
Make
I did what I can. It's out of my hands.
Yeah. Awesome.
Thank you.
Chris.
It's really a pleasure.
Bye.
Bye-bye.